Hello, everyone, and welcome to today's webinar, Copyrights Ins and Outs. We appreciate you joining us today as we look at this important issue from a legal perspective, and I want to go over just a few things before we jump in. So we will be recording this session, and we'll send out an email with a link to the video so you can have access to the material. We also welcome your questions and love to hear from all of you who are joining us live. So you can ask your questions anytime throughout the presentation on the right-hand panel of your GoToWebinar panel. There's a questions tab there. So feel free to type those in at any time. And we'll get to some during the presentation and we'll have time for others at the end. So I'm Hannah Curtis. I'm a coordinator with the North Metro SBDC, and I'm so happy to introduce to you today our speaker, Samantha Peasley. In addition to a North Metro SBDC consultant, Samantha is a lawyer with Polaris Law Group and specializes in intellectual property law. So we feel very lucky to have her expertise. And Samantha, I'll turn it over to you.
Thanks so much, Hannah. I appreciate it. And welcome, everybody. Today, we're talking about copyrights. So if you're expecting a different webinar, I'm sorry, you're not in the right place, but feel free to stick around. You might learn a few things. If you've been to any of my other IP webinars, you'll know that I've touched a little bit on copyright, but today's really our deep dive. We're going to be learning what copyright is and how to use it. If something that I say in here makes you realize that you thought you had copyrights, but you might have a different kind of intellectual property, I do have some other webinars. Yes, you do have IP. We also have Fair Use 101, which talks more in depth about one of the defenses that we'll get to today. Or you can just reach out to the SBDC and schedule a consultation, and I'm happy to help. But let's get started. Let's learn a little bit about copyright. So we can't really learn about copyright until we know what intellectual property is. Intellectual property is that intangible idea that you have property that is some sort of invention or creative aspect or a brand identifier. It's not the physical book, it's actually the text within the book. So there are 4 types of intellectual property. We have patents, which are your inventions. We have copyrights, which is what we'll be talking about today, which are original works of authorship, usually considered to be creative, but doesn't have to be creative as long as they're original works of authorship. Trademarks, which are brand identifiers. They let consumers know that something is coming from you. And trade secrets, which are kind of the fallback, the catch-all. They're intellectual property that doesn't fit into one of the other categories, but that gives you a business advantage over your competitors as long as they're secret. So we'll be talking sometimes about the way that those things interact. If you have questions, sometimes my answer is that you're not actually talking about copyright, you're talking about one of these other ones. So it's good to know at the outset that there are those 4 types. So now that we know those, let's get to the meat of what we're talking about. What is a copyright? Copyright is a form of protection for original works of authorship fixed in a tangible medium of expression. So those 2 points in those quotes are the most important parts of copyright. Original works of authorship fixed in a tangible medium of expression. What does that mean? No ideas. So the idea of a orphan wizard boy who goes to a magical wizarding school is not protectable in any way, shape, or form. However, the books of Harry Potter, the characters within there, the spells, those are original works of Miss J.K. Rowling fixed in a tangible medium of expression. So very important distinctions there. We'll go into original in a bit, but tangible, exceptionally important. So this includes literary works, dramatic works, musical works, architectural works, which is oftentimes a forgotten portion of these, choreographic and pantomimic works, pictorial, graphic, and sculptural works, audiovisual creations, and sound recordings. And you will notice at the bottom, the Copyright Gov page has all of this information as well as breaking down each of these individual sections for you. So I'm about to go into a couple of these specifically. I understand that with SBDC, we all deal with a lot of different forms of copyright. If I don't touch on the ones that are applicable to your business, I do apologize, but we can talk more about them. Also, just an interesting thing on this point, this copyright protection, even though you'll notice there's a statute there, 17 USC 102, is actually a protection in the Constitution of the United States. So it is that kind of ingrained in our society that we want to give people these kinds of protections. So literary works, what are some common literary works? That all came up at once. Blogs, those are literary works. They're anything that is that original work of authorship about words around the written word. Manuals, books, and computer codes. A lot of people mistakenly attribute computer programs, computer codes to patent law. That is not necessarily the case. The code itself behind the software, the app, is actually a literary work under copyright law. It is only if that extends to an invention that it would be patentable. Musical work and sound recordings, we use these often. Compositions are considered distinct from sound recordings. So any of those songs that you hear on the radio will actually have two separate copyrights in them. The first one for the composition itself, meaning the music and the lyrics, and the second one for that specific recording of the work. Then you have pictorial and graphic works, which are designs, drawings, computer-generated images, photos, clip art, anything that is that image that you see, and then audiovisual works, which is typically just video. There are a couple of other examples. So these are kind of the main ones that we see people work with. Obviously, choreographic pantomimic, very important, dance companies, etc. Architectural, exceptionally important, but these are kind of the meat of that copyright. So I would like you all to meet my hypothetical business, Cassie's Cupcakes. Cassie is a cupcake baker, who also likes to have a teaching aspect to things. She is starting a cupcake shop, and she will be our examples throughout the day. So anytime we see Cassie's Cupcakes, I'm going to kind of explain a little bit in that narrative, and then that will be that opportunity for I'll ask Hannah for any questions that have come up through this point. So Cassie is starting her cupcake shop. She has the following items that she thinks might be copyrightable. First, she has her cookbook, Cassie's Cookbook. Well, obviously a cookbook is a literary work. It might also have some pictographical works in there too, if she has pictures of them in there. Cooking class videos on YouTube, if she's showing people how to make her cupcakes, she will have a copyright in those. Cooking class handouts and materials, if she is doing those classes and she provides things like PowerPoints to them, or if she provides them things to take home so that they remember what's going on. Photos of her cupcakes, photos from within her store because it's super cute and creative. Any blog posts that she does about the various cupcakes that she's doing, as well as cupcake art, because she's got cupcake art everywhere. She also has something very unique that she wants to do, which are cupcake booths. So basically you have a giant cupcake that is hollowed out in the middle and people can sit and knit around booths. That's Cassie's Cupcakes. So any questions about the basic, what is a copyright? And Hannah, are you going to read these or would you like me to read them?
Yes, yeah, we do have some great questions that came in. So first one, can you copyright a picture with a phrase, like the combination?
Oh, excellent. So yes, and we'll talk in a little bit about derivative works. If the phrase is yours, then you can copyright that whole thing. However, if the phrase is someone else's, then you might only be able to copyright the picture itself. Similarly, if the phrase is yours and the picture is someone else's, you may only be able to copyright the phrase and not the picture. We'll get more in depth on that one in a second, but good question, yes.
Great, thank you. Another question that came in, what about websites? An example that someone mentioned was wondering if they could copyright, www.theiraddress.com in a whole.
Great. So there are two parts of that question. So the website as a whole, yes, you can copyright, but that is not in fact your domain name. Your domain name you can trademark, or sometimes they don't have any meaning whatsoever. So just by having the domain name does not mean that you have a trademark. You can't actually copyright a name or a word. Those are brand identifiers. So that's one of that other categories. However, the look and feel of your website, the actual content on it is in fact copyrightable.
Great, thank you. That's really helpful. One more that came in real quick from Kristen. She asks, are online courses protected if placed in electronic platform, even though using other people's resources in accordance with copyright? For an example, linking to like original content. Can your organization of resources be copyrighted, or only your original videos or handouts you create?
Okay, so if we're going to get into ownership in a second here, and I think that we'll go more in depth on that, but as a very basic answer, those videos are copyrightable. If they're not yours, then you can't copyright them. So if you have a compilation of other people's items, that's not copyrightable. Those are other people's resources. We will get a little more in depth, and I will come back to that question as we go along, because there are going to be some other things that we talk about that will open up some other ways of how to do that.
Great. All right. Well, thank you. Those are all of our questions for now.
Perfect. So now that we've learned basically what copyrights are, let's kind of learn about some of those nuances about that original works of authorship. So first of all, we have to break down what is original. You might think that this is silly to focus a lot on a word, but a lot of case law, a lot of ink has been spilled over this over the last 150 years. So what of the part of it is original? Overall form, arrangement, and composition. So an example that I like to give, and this is a very famous example, is a picture of the maroon bells. Well, obviously the maroon bells itself are not original to the owner of the picture. However, the form of the picture is, the arrangement is, what angle they decided to go out, what time of the day they decided to go out, and the composition, how they decided to edit it, what colors they decided to use, what lighting they decided to use. Now, this is distinct. This does not protect the work that the photographer did. That's a different category. That's trade secrets. However, that ultimate picture of the maroon bells is protected in the way that the photographer decided to depict it. So that's what originality means. It also means that copyright is not going to protect the standard features. That doesn't mean you can't have standard features and not have copyrighted. It just means you can't prevent other people from using the standard features. So for example, in a website code, if there is a base code that you're using, especially for something that happens in everything, such as a contact form, if you have a particular code for the contact form and it's the same on every website, that's going to be considered a standard feature. Similarly, if you have the, I clicked early, sorry about that. If you do have on something such as a photo, you have a particular watermark or a particular design in there, that might be considered a standard feature. So if everyone who's doing this thing has this thing, that's not going to be considered original. You also can't have anything inherent to function. So for example, in an architectural work, if you have iron bars on something for safety, you've designed this really cool house and you decide to put those on there, that's not going to be considered copyrighted. If you have put those iron bars in a really interesting pattern or design, that would be, because that pattern or design is not inherent to the safety function. Similarly, in a book, table of contents, the existence of a table of contents is inherent to function. It is not copyrightable. You would not be able to copyright a table of contents itself or page numbers. So that's what comes in with original. And one of my favorite examples of this, and this is a legitimate case, is the leg lamp. This is a lamp that it's a lamp. It's a useful item, right? Is the leg part of it inherent to its function? No. Is the overall form, arrangement, and composition of the lamp original? It's pretty original. Are there standard features? Yes. a lampshade and the actual electrical cord and the light bulb are not going to be included in the copyright. That is your example of original. So derivative works comes up a lot with originality. So one of the rights under the Copyright Act is your ability to create derivative works from what you have created. That means something that is built from something else. An example of a derivative works can have their own copyright, but they're not fully original, right? So you're going to exclude anything from that copyright that is a derivative of an earlier work. And if that derivative is of somebody else's work, you better have permission to do it. This is an exception to originality with that limited portion. And now this is different from simply taking a quote and giving attribution. So if you're doing a blog post and you're wanting to cite somebody else, and you just do that one sentence, that's not going to be a derivative work. You will have to exclude that attributed portion from copyright in the same way that you would with a derivative work, and you will still need permission, which we'll discuss later when we talk about those rights. But mere attribution does not make something a derivative work. It has to have been built off of it. So for example, to this is the most recent Beauty and the Beast. Should not be using this picture. You'll see that later. However, I'm breaking the rules ever so slightly for this because it's a great example. What is this a derivative work of? Well, this Beauty and the Beast, of course, but Disney owned both of these. And so it can take and make a derivative work because it has the right to do that. It owns that copyright. And it got permission from anybody else who's there. So the story can be the same, even some of the art can be the same. You'll see that Belle's dress is the same, a lot of the names are the same, the music is the same. You have the new ones, but the only thing protected in the new Beauty and the Beast is going to be what is different from the old Beauty and the Beast. So the actual audiovisual will be protected because it's all live action rather than animated. Any of the new songs will be protected, the choreography will be protected. But overall, it's less strong. It's a derivative work of the original. And the original is a derivative work of, oops, wrong direction, the story Beauty and the Beast, which is in the public domain. So anyone can actually make a story off of Beauty and the Beast so long as you're not copying protected elements from either of those other works. So that's kind of the nature of a derivative work. So to give an example, we're back to Cassie. Cassie's cookbook. She wants to design her own cookbook. Most of the recipes are Cassie's own. Are they original? Well, let's go back to that definition of original. Is the overall form, arrangement, and composition hers? Probably. However, is the recipe inherent to function? Well, to the extent that you have things like measurements or temperatures, that's going to be inherent to function. It is exceptionally difficult to copyright a recipe. It will be there, but it will be very, very weak. And to the extent that it's just the list of ingredients, list of instructions, probably not copyrightable because they are inherent to function. You'll notice that's why if you ever go look up recipe blogs, that there's all of that content up there. That's also for SEO purposes. It drives us nuts, but it's both necessary to create something original and to take out some of that function. There's one recipe that Cassie wants to use with an attached story from it. So that's that story part that she got from a food blog. If it's in the cookbook and the cookbook is Cassie's, can she use it? Well, so Cassie is taking something that is somebody else's and putting it in one of her own. The cookbook will still be protected, but now we have a derivative work in there. She's taking that story and that recipe wholesale. She's going to need permission to use that because only that author has that permission. What if she gives the author credit? Great, fantastic. Doesn't negate the fact that Cassie does not have the right to use that. It's a derivative work. So, any questions so far? Originality, derivative work.
You did a great job explaining that really thoroughly. So thank you for laying that all out. We don't have any more questions right now. Oh,
Great.
as I say that, one comes in. Oh, This is, I guess, a side question. Will any of this content be shareable for folks after the webinar?
Absolutely, we'll send it out to Hannah, and people can see that. Just remember, this is my copyrighted work, so don't share it with other people. But for educational purposes, absolutely.
Great, thank you.
Perfect. And we will come back to some of this. And for the one of you that asked about the educational videos on your website, I haven't forgotten about you. We've talked a little bit about derivatives. We're still going to get to some of the other stuff that goes into that question. So, authorship and ownership, really important. Who owns a copyright? The original and automatic owner of a copyright is the author. It's the creator. It's the person who makes it. Okay, that's very important. Why? Because as business owners, sometimes we can't make all of our own things. So somebody asked about a website earlier. What if I hire somebody else to make my website? I kind of give them my general idea, give them my general color schemes. Here's what I want, but they do all the writing. They get the pictures. They take the pictures themselves. Is that mine? Default? No. The automatic author of that is the website designer. And they will get that copyright in that website for the life of the author plus 90 years. Hopefully I'm not using the same website in 90 years, much less the life of the author plus 90 years, but that is the default rule. We'll talk about how to get around that default rule in a little bit, but very important to remember that the person who owns the copyright is the author. So if you have two authors, then they're co-owners. You don't have to designate who owns what part, they're just co-owners. So if you did 90% and your business partner did 10%, you're still co-owners, again, without anything else to switch that around. Then it's the life of the last surviving author plus 90 years. So if something is a work made for hire, meaning that it is done in the course of employment or specially ordered or commissioned if it is expressly agreed to be a work made for hire, that's not the best way to do it, but that is one way to do it, then it is either the earliest of 95 years from the first publication or 120 years from the creation. That's the institutional rule. So if you are doing the work on behalf of your company, then your company owns the copyright and it will last for either the 95 years from the first publication or 120 from creation. So if I specially ordered or commissioned my website, and in specially ordering or commissioning that in our contract says this is a work made for hire on behalf of Polaris Law Group. Now Polaris Law Group owns the copyright, not the author who created it. But again, the default is the author. Doesn't matter if you guys said it, doesn't matter if you both knew that this was totally the case, doesn't matter if they don't want it. They are default the author, unless you specifically agree otherwise. Ownership of the copyright is not the ownership of the material object. So to stay with the website, you asked about the domain name. The domain is the material object. You pay a company to be able to use that domain. Ownership of the copyright in the website does not give my independent contractor ownership in that domain. I still have that. It just gives them the ownership over the rights that come with copyright, which we will get to, but we already discussed like the right to create a derivative work from it. Similarly, J.K. Rowling owns the Harry Potter stories. I purchased my copy of Harry Potter from a bookstore. She does not own my copy of the physical book, but she does own the rights to prevent me from making photocopies of that book to distribute on my own. I have to get that through contract. So that's general authorship and ownership. Defaults, kind of how you go around it. So coming back to Cassie, this is a short jump, but Cassie wants some booths designed like Cupcakes. Talked about those earlier. She also wants general design for her space. So she calls Andy the architect and he offers to create some designs for her. Remember, designs, pictorial or graphic representations. Andy comes back to Cassie a week later. He has some actual drafts for her store space, her cupcake booths, and cupcake art based on her drawings and budgets. She did some kind of rough drawings, gave to him. He created some derivative works of full designs. he has used a common software to design these. Who is the owner of Andy's designs? I don't see any evidence of a contract in there. So the default is Andy is the owner. Now, if he did it based on Cassie's drawings, Cassie still has that copyright in her drawings, and he has a derivative work. If Cassie didn't do drawings, she just told him, like, here's generally what I'm thinking about, not a derivative work, because she only has an intangible idea, not a tangible work of authorship. Now, her drawings don't have to be good to be tangible. And if his is a derivative work of those, then she would own those original drawings. Andy still owns his. One way to get around this would be if Cassie did a contract with Andy that said, you are doing this as a specific work for hire, or, so we're going to talk about in a second, license or assign. So any questions about ownership and authorship?
Yes, we did get a couple. Actually, we got quite a few in here. So let me. Okay, this I thought was a good one. So, who would be the author if a work was created for while that person was working for an employer? So I create something while I'm working for an employer. Is the employer, the company, are they the author? Do they have that copyright, or do I, as the creator, have that copyright?
If you are doing it as part of your normal job duties for your employer, then the employer is the owner. You are doing that as part of your salaried or hourly work for the owner. They are default the owner. So if it is an employee-employer relationship, default is work made for hire. If it is an independent contractor relationship, default is not work made for hire. The exception on the employee-employer situation is if you are not doing it for the benefit of your company or in your job day. So for example, if you are hired to do, let's say, accounting work for your company, but they don't have a website person, they don't really want to do this, and you're like, we need a new website. So you go and design a website for them. You are specifically doing it for your employer. You're not getting a specific independent contractor agreement. You're not getting any sort of other thing, but you're doing it on their time for their benefit, even though that's not part of your normal job description. That will be considered for your employer. However, if on your free time outside of the office, you decide to make yourself a website, that's not going to be considered your employer's. So be very careful with this, because that means that if you are, and the law does say that if you're doing things on company time, that is going to belong to the employer, even if it is your personal website, because you are getting paid to make yourself a website. That's going to belong to the employer. So excellent question.
Great. Thank you for that answer. Another question related to this. Carrie asked, if I were asked to design a logo based on someone else's design, but then changed the vector image and font, but have the same layout and common phrase, who becomes the author of that?
So similar to the Kathy's drawings, you now have a derivative work of that person's design. So they still own the tangible medium of their design. You are the author of the changed and altered and supposedly improved, probably, design that you have made. So they are the original author. You are the author of the derivative work. And so if they revoke the right to use their original from you, then you're only going to have very limited rights in that derivative work.
Great. Thank you. A couple of related questions came in around permission. So if you have a website and you are wanting to include links taking your viewers directly to the original work, like with the example of the recipes and the blog, you would take them to the original blog owner. Do you need permission for that? And similar in that same vein, do you need permission if you have a section in your website where viewers can type in their own stories or their own experiences? Do you need permission then to use those stories, or does the act of them typing that in count as their permission?
Good questions. So on the first one, because that one's the easiest, By linking to other pages, you don't need permission to that, because you're not actually, by the simple act of having a link on your website, that's not a derivative work. That link, again, is not copyrightable. So even though the material that the link goes to may be copyrightable, the link itself is not copyrightable. You're not creating a derivative work. You do not need the permission to do that. However, if you are posting like the full recipe and then putting the link underneath, the posting of the link is not enough to say that you don't need permission for the rest of it. So link by itself, good. Link as a source of attribution, not so good. Kind of a trickier thing. If people are putting their own comment stories, things like that in there, that is an excellent question. Typically speaking, they are still going to be the author, but by posting it in a way that they know how you're going to use it, they've given you permission to keep it on the site, so it can become that derivative part of your site. You wouldn't be able to go get copyright in any of the stuff that they have posted on your site, and you would not be able to go take that and publish it in another medium. It is still their work. They are still the author, but what they have done is they've now given you permission to use it as a derivative by that form of posting, if they know that that is how it's going to be. If they think that it's going to be like a secret submission, then that's a different story. And you should always disclose those kinds of things. But yes, that would be they're still the author, they're still the creator. You just now have permission to have that posted.
Great, thank you. One more question that came in along these lines of permission. Do you need to include the copyright symbol on every drawing or every work that you are wanting to be protected?
Excellent. We're going to talk about registration in a little bit, but the answer is no, please don't do that. You will be fined. You can only use the copyright symbol if you have a registered work with the United States Federal Copyright Office. You own a copyright at the moment of creation. What you need to do if you don't have a registration, you'll notice on my PowerPoints, I have the word copyright with the year and who made it, the author. I did this on behalf of my company, so my company owns them. You must use the word and not the symbol if you have not registered it. I haven't registered my PowerPoints. I'm lazy and I change these constantly, so I don't feel like it. If I were to use the copyright symbol, I would be fined if that was seen. So do not use the copyright symbol. If you want to use the word copyright, we'll talk about protections later and how that can help you with that. So,
great.
All right.
Thank you for
Sorry, go ahead.
Oh, just thanks for all those great answers. Those are our questions for now.
Awesome. All right, so lots of still good stuff to get into, guys. No worries. Fun things. So protection. How do we protect your copyrights? Here's the first one. If I'd known it was the next slide, I would have just skipped the slide and kept going. There are 3 ways to protect your copyright, and the more of them that you do, the stronger your protection is going to be. And I will say right now that these 3 ways are the same for patent and trademark as well. However, you cannot register trade secrets because then they wouldn't be secret. So that only the other 2 are applicable for this. So registration is one way to protect your copyright. Contract is another very important way to protect your copyright. And action is the final way to protect your copyright. Venn diagram, this is a true Venn diagram. If you do only one of these, you'll have some protection. If you do at least 2 of them, you will have much stronger protection. If you do all 3 of them, you will have the best protection that can be afforded to you under copyright law. So we'll go into each of these individually. First is registration. You can do online registration for your copyright. Luckily, copyright is the cheapest of all of the intellectual property forms. So I hope you guys can still see this. If you go to copyright.gov/registration, you will see the registration portal, which is fairly simple to use. You log in, you can see the FAQs on the processing sign. Once you have registered, so you are able to, when you create your copyright, you have some protections in your copyright because copyright comes about at the moment of creation. Those protections are that other people can't copyright or use it without your permission. However, this is governed by what we call common law, which means that if somebody does use it, you only have protection in the area in which you have published that copyright or to the extent that you have created it and might have it. And you can only sue them in state court. You also will not get any of your attorney's fees back. If you register, you can sue in federal court. You can use the little symbol that says that you have registered it. You can then get international registrations, which can be very difficult to get without a US registration first if you have created it in the US. And you get some presumptions if you do have to bring it to court, such as the presumption that you have a valid copyright versus the need to prove that you have a valid copyright, as well as some of your statutory fees and things like that back. So registration is a great way to protect it. Also, I will tell you that if somebody is worried about infringing a copyright, they come to somebody like me to check that. I can go onto the copyright.gov and see if somebody else has a copyright that my client might be infringing, which means that it is less likely that my client is going to infringe it if it's on there. It might be harder for me to find otherwise, because then I have to search the entire world of everything. So typically we go to the copyright.gov and then we do some basic searches elsewhere, but you're less likely to be infringed upon if you have a registration. So that's the first type of protection. However, like we said, not necessary. And if you have contract protections as well, this makes it stronger. We already talked about contracts a little bit with the work made for hire. The default is the creator, but that if you specifically say that you have a work made for hire, that you may have that protection of you owning it. There are really 5 types of contracts that can protect your copyrights. One is a confidentiality agreement. This you definitely don't need registration for. It's a good fallback because even if you don't have a valid copyright, you have something that maybe has a weak copyright, if you have somebody else who you're giving this to sign a confidentiality agreement, they're agreeing to be bound by contract not to share or use that aside from the ways that you've given them permission. NDA is very similar. It's a non-disclosure agreement. Usually you'll see these 2 things combined. However, in some situations, a confidentiality agreement is more appropriate than a non-disclosure and vice versa. Employment agreements. If you want to make sure, if you're the owner and you want to make sure that anything that your employees create is yours, you can line that out very specifically in an employment agreement. You can also say they're not allowed to take your manuals elsewhere or your policies elsewhere or post them on Facebook. These all help protect your copyright. Partnership and service agreements for those times that you have those relationships with others that aren't your employees. Maybe they are contractors, maybe they're people who work with you, maybe they're your website designer or Andy the architect. You can protect your copyright through these agreements. And finally, license agreements and assignments. Sorry, assignments wouldn't fit on it with there. These are what actually transfer ownership or maintain ownership in copyrights. So for example, license agreements. These 2 slides are backwards, so I'm going to skip one and I'm going to come back to this. License versus assignment. A license is a lease. You're renting a house, you're renting the intellectual property. It does not take it away from the owner, it just gives you permission to use it. An assignment is a full sale or transfer. So I said earlier, work made for hire clause in a contractor agreement is one way to make sure that you have it. A better way to do it is a full assignment. This means that it's not any dispute later as to who owns it. It's just saying, I understand you're the creator and that this is yours and I'm paying you to do this and I'm paying you to sell it to me. You are agreeing that you are giving all of your rights to me on this. You'll get different opinions on that from different attorneys. This is my personal opinion. This is not legal advice to go switch all of your work made for hire agreements to assignments. But it is one way to do it. You must have for either of these what we call consideration, meaning you can't do it for nothing. It can be the price that you're doing for having them create it, for having you pay for it, any of that. But you should keep these two distinctions in mind when hiring people to create your copyrights, or when you're hired to create other copyrights. For any of you who have ever gotten married or are getting married, I will tell you a place that you'll see that these two distinctions a lot is in wedding photos. Some photographers like to license it because they want the ability to continue using them afterwards. Some prefer to assign it because they feel that the person has paid for it and that they should get it, and then they might ask for a license to use it for limited purposes. That is one where we've seen no industry standard versus most industries which have a standard as to whether they prefer a license or assignment. So going backwards, license agreements, there are different ways they can be. They can be express. That means yes, I agree that you can do this. You actually say it. Versus implied, which is you hired this person to create your website for you. It has your logo all over it. It has your information. It is implied, even if you don't end up having a written agreement with them, that you have a license to use it. And that is what that fallback is with when you have a contractor who creates something for you with your payment. If you do not have a written agreement otherwise, they own it and you have an implied license to use it. Now, if it's just implied, it's also going to be non-exclusive. What does that mean? So we said that it's a lease, right? Non-exclusive means that they can also, so you didn't get the whole house. They can lease out that bedroom and that bedroom and that basement and that kitchen. Other people can use it. And that, oh, by the way, when they're in town, they can also just come and use it at the same time that you are. They can come crash on the couch. Non-exclusive means that other people can use that same thing. This is really, non-exclusive licenses are really common in, say, supplier distributor agreements, where you're going to have multiple distributors. So you need them to have, say, your marketing materials. You need them to have the photos of what you're doing. Let's say that you're selling a soap and you want multiple stores to have that. It comes with this copyrighted materials that you're giving them. You want that to be non-exclusive. Exclusive, on the other hand, means you are the only person to use it, and you must have a contract for something to be exclusive. Now, license agreements are not governed by intellectual property law. They're governed by contract law, which varies from state to state. Most states are fairly consistent with license agreements and with these rules, but you may not be able to have the same license agreement for each of the states that you're operating in, or you should make sure that they're governed by Colorado law. So let's add some facts. Andy, from Andy the Architect, is a responsible businessman with a great transactional attorney that he works with. At the beginning of his work with Cassie, he presented her with his typical work agreement, just one single contract, which includes a confidentiality and non-disclosure section, as well as a license agreement. Key thing, license. Cassie was satisfied with these, so she signed them and did not provide him her own documents. The license agreement says all confidentiality and proprietary information, as well as all drafts and deliverables, remember he did those designs for her, created by Andy for this project, Andy's intellectual property, shall be the copyrighted materials of Andy. Andy grants a non-exclusive limited license to Cassie to use all deliverables and drafts created for her other Cupcake stores, which Cassie opens based on these designs. This license does not extend to any store sales, leases, or other purposes besides those expressly stated. So Cassie now wants to open, she's been exceptionally successful. She's used Andy's designs, they're fantastic. And she wants to open another store in a different state using different professionals, but the same designs. Can she? Well, let's look. She has a non-exclusive limited license. That means that both Cassie and Andy can use these, but it's limited. So what is it limited to? Only for other Cupcake stores which Cassie opens based on these designs. So yes, Cassie can absolutely use these in another state without having to go back and ask for Andy's permission. If Andy had assigned these designs to her, so sold them, Cassie would also be able to use them because they belong to her. If he had given a license that said you can't open other stores based on these designs without asking for my permission first, she would not be able to use them. So any question, oh, and sorry, so finally for actions, because I didn't mention that one, actions would be that whole marking things as copyrighted, acting like things are copyrighted, not giving people your copyrights without permission, Why? Because that puts people on notice that you believe that these things are copyrighted. So, Hannah, any questions? We still have 2 more sections, I think. So, but any questions on this part?
Okay, yes, I'll just read some of the questions that pertain to this. One of the questions was regarding employment agreements. Is an email with a statement of work sufficient for protection? I know you mentioned the written record of statement, but would an email be sufficient?
It depends. That's totally one of those factual situations things. In some circumstances, yes, but we would consider an email more on that action side rather than the contract side. You're providing notice of what you think. And if they don't object back to you, you may be able to argue that that is a contract, but you'd have to argue that it's a contract. Typically, a contract is something where you have offer, consideration, offer, acceptance, consideration, and both parties, or at least the party against whom you're trying to enforce it, has shown that they have agreed to it affirmatively. So if a statement of work is done, but nothing is exchanged between the parties, that's not going to be a contract. It might be an action that shows that they know that you think that they that everything belongs to you, but that's not one you want to go to court on, to be completely honest. So best to have contracts that are actually signed by both parties. You can do electronic signatures, but email correspondence is sometimes a contract, sometimes not, and you have to fight over the facts to determine that.
Got it. Thank you. Those are our questions that pertain to this for now. So I think we're good to go for your next section.
Cool. All right, hang in there with me, guys. We're almost there. Just 2 more. So this is the one that everyone gets excited about. What are my rights? So I have all these copyrighted works. What can I do with them? So copyright owners have the exclusive rights to do or authorize the reproduction of their copyrighted works. So copying, the preparation of derivative works, which we talked about. You can't make a derivative work without the authorization of the original owner. Distribution of the work, and this goes back to our educational platform example. So by putting something onto an educational platform, you are distributing it. So you need to have those authors, the ones who made the videos, permission before you can distribute it like that. So something like putting something on YouTube, that's distribution. Transfer of the ownership, rental, lease, lending, sale, license, assignment, display, usually for pictorial or graphic works, but you have to have that permission to display it. And attribution and integrity, and this is only for visual work. So for example, a photographer has the right to have the work attributed to him or her. Integrity also means that they have the right to determine how that is viewed. So if it's done in a way that is mocking it or mocking something that they believe in, they have the right to say no. If it's a written work, you don't have that same permission. If it's an audio work, you also don't have that same permission. So this is what you can do with your works if you have a copyright in the work, and it's what you can't do with other people's copyrighted works. Very important there. So now you'll notice that linking to things is not on here. That's why you can put website links. The website link itself is not copyrighted, and that whole referring people to another work or referencing another work is not, in fact, a right of a copyrighted work. You just can't reproduce it or otherwise distribute it. Linking to it is not actually considered distribution because you are not actually like sending it out to the world. You are inviting them to go see it. It's a fine line, but infringement is violating one of these rights without, 2 keywords here, permission or defense. So that is why I keep saying permission, 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 because if you have permission, you will not be infringing. The defense comes afterwards. You are still infringing even if you have a defense, and that's going to be our final section, is that those defenses. But you are infringing first, and then you have the defense. The defense does not mean you are not infringing. Infringement can be shown through access and substantial similarity. Why is the access important? What if you came up with the idea of an orphan wizard who went to wizarding school separately from J.K. Rowling? and you had never seen it, let's say at that point in time it had not been published, and you publish a very similar work that has some very similar sections in it, so substantial similarity. If you had never seen it, if it had never been published, then you could say you had no access. I will say for anything that is widely distributed, the default is that you are considered to have access, even if you say you have been living under a rock and you have never seen Harry Potter. Too bad, so sad. You are deemed to have seen Harry Potter when something reaches a certain level of popularity. But if you had done this in the 90s before she had gotten famous, then you would not be considered infringing. If you had no access, it was not famous, even if yours is substantially similar. Substantially similar is a fact question. It is a difficult one, and it is not one you want to be fighting with on the courts because every person thinks differently on it. But that is the test for it. So Cassie now wants to take pictures of her building, inside and out, including the cupcake booths that Andy helped her design to put on her website. Can she? So remember that Andy has some rights in those cupcake booths, and his rights include reproduction. Well, if she's taking a picture that's not actually a reproduction, is it preparing a derivative work? Yes, a picture of that kind of work is a derivative work. It's a copyrighted work. She's taking a picture. You can't take a picture of, I was about to say the Mona Lisa. That one doesn't work because that one is public domain. You take a picture of somebody else's work, let's say a Banksy production, that is a derivative work. So Andy has those rights in there. Now, for the cupcake booths, which might be sculptural or might be architectural, there is actually an exception built in. But generally speaking, you would need his permission for that. What if she wants to add that classroom space to the back of her building? Is she required to bring him back for that? Well, we saw the license agreement earlier, so we know that the answer is no. If there wasn't a license agreement, probably not. She owns the building, she has that right. But if she uses his original blueprints, can she? Now that's a derivative work again, and he has that permission over his own derivative works. So that would be a closer call, and it would be one where my default would say, go ask him for permission. Like, otherwise you're going to have to show that you didn't have access. We know you had access. Are they substantially similar? Do you really just use them for information, or do you really use his blueprints? If you used his blueprints and we can tell that, substantially similar, you're done. Don't do it. Ask his permission. Any questions on those rights and infringement?
Yeah, a couple quick questions. What is the best way to get permission? Can it just be an email, or is there like a standard way to get permission?
It depends on who you're asking. If it's one of your contractors, obviously that's the easiest, and you want that to be in the contract because that way you don't have to worry about it later. Otherwise, email is fine. Again, the lack of them answering is not okay. You want to actually have something that has their signature on it that says yes. Usually I say print it out and file it. Other ways to get permission. So sometimes if you're using photos for your website, there are sites that you can buy a subscription to, and the artist or authors who have who are members of that site have already given their permission to the site. So by being a subscriber, you get permission. If it's a more specific thing, you want to reach out. If it is something like a musical work, a movie, or a book, so a true like in the industry sort of thing, there are particular forms that you want to use, especially in music, because like I said, you have those multiple copywriters on everything, the multiple owners. So in those, you want to use the specific forms, but if it's casually for your work, one of those other ways is just as good.
Great. One more quick question on that. How do you search for things that are available in the public domain?
Excellent question. It's hard. Wiki Commons is fantastic because it is people who have put it out there. Creative Commons is another source that is fantastic. You can also look it up on the copyright website if you know that it was at one point copyrighted and you want to see if it's out of copyright at this point. You can go to copyright.gov and do that research. I'll tell you that if you know that it's before the 1900s, it's in the public domain, so that's a safe bet. You can also look at the work that you're using, and if it has a copyright notice or it has an invitation to reach out to somebody, then you'll know that it is still considered copyrighted.
Great, thank you. Those are all our questions for right now.
All right, last but not least, again, on this section, I actually do an entire full webinar on this section. So if you have more questions on it, I am happy to do that, or we can let you know, let Hannah and I know, and we'll let you know the next time I do a presentation on it. And this is fair use. This is the most common defense. It is also the most commonly misunderstood defense. A lot of people just throw things out there as fair use. My least favorite one that somehow got around a few years ago was that if it's on Google, it's fair use. That's not true. Don't do it. If you take nothing else out of this presentation, please, for the love of everything, if it being on Google does not make it fair use. So fair use is one of those defenses. So like I said earlier, this does not mean you haven't infringed. It is just a defense to infringement. What is way easier? Getting permission if you can. However, there are some reasons that you can do fair use. There are 4 considerations. There is no right answer on this. There are some things that are very definitively not fair use. There are some things that we're pretty accepting are fair use. At the end of the day, it's a judgment question, and the judgment will come down to these 4 ideas. What is the purpose and character of the use? For example, is it for profit versus educational? Earlier, I used some pictures that I told you I probably shouldn't, but I was doing anyway. Did I have, what is the purpose and character of this use? It's educational. Is it for profit? You all paid to do the webinar, so it's going to be balancing out those 2 factors. Small business education, is anyone going to come after me for it? Possibly, because Disney likes going after people for things. But that is one of those things that will be weighted. What is the nature of the copyrighted work compared to the nature of the potentially infringing work? Well, the copyrighted work there were 2 images that advertise for a movie. The nature of my work is not a replacement of those images, it's the use of them in a PowerPoint for educational purposes. I'm not really profiting off of the use of the pictures. I am more using them as an illustrative purpose. So that nature of them, they are definitely a copyrighted work. And they are definitely a work that has strong copyright, which is what you look at, versus something with weak copyright is not going to be as much. The amount and substantiality of the portion used, I didn't use the full videos, but I did use the full pictures for each of those. I used 100% of that copyrighted work. How substantial was it? It's a pretty substantial piece of that. Then you compare it to how substantial was it in the course of this presentation? A very small portion in the grand scheme of things, not even the biggest portion of that particular page that they are on. And then the effect of the use on the potential market or value. Is my usage of those pictures going to prevent other people from going and purchasing the art from those movies? No. Is my use of those pictures going to diminish the people purchasing those? Well, if they try and pull the pictures directly from my PowerPoints, perhaps. Those are the things that you weigh in there. Am I going to give an actual determination as to whether my use of them is fair use? No, because again, that's going to vary from person to person weighing those considerations, but they are important considerations. Important thing to take away from this, if it is your business website, even if it's your blog on your business website, it is almost certainly not fair use. I don't want to fight it in court for you. I will just tell you, we can weigh these factors all day. Not going to do it. I will tell you also, one of the reasons I used those pictures in this website is to have this example here. You'll notice I did not use any other copyrighted works within this presentation. I used them for the specific illustration later, as well as the use of them there. I don't typically recommend using copyrighted materials in PowerPoints, especially if they're pitches that you're giving to clients, or if they're not strictly for educational purposes. If they're for educational purposes, you're not getting paid for the presentation, that's one thing. If they're for a elementary school, you can probably do it. If they're for clients in any way, shape, or form, I highly recommend thinking twice about it. I'm gonna skip this one just because we're at the end, so I'm gonna pull this up and ask for any final questions. Sorry I brought you guys right to the edge of this, but I hope that this was exceptionally helpful. I will be giving this to Hannah. Any final questions before we go?
Yes, thank you so much, Samantha, for all of this information, and thank you everyone for all of the questions that you submitted. There were a bunch coming through, so if any of your questions were not answered, or if you want to dive into any of those deeper, please visit our website. It's northmetrosbdc.com, and we can get you connected with Samantha or any of our other consultants to go through, your more specific questions and situations, because it is a very important topic. So we so appreciate this thorough presentation. And like Samantha said, we will send it out with the recording to this webinar. So any last words from you, Samantha?
No, thank you guys for coming. Please feel free to reach out, like Hannah said. And I hope that this has helped everybody understand if you have copyrights and what you can do with them and what you can do with other people's.
Great. Well, thank you so much. We really appreciate your time. And again, our website is northmetrosbdc.com, where you can schedule an appointment with Samantha or any of our consultants. So thank you all for joining, and we wish you a great rest of your day.
Thanks, guys.